introduce the topic, recent employment regulation and risks. Don, if you've been at any presentations, you know he has a wealth of knowledge. He is a managing principal of Jackson Lewis in their Orlando office, and he specializes in all aspects of employment law, representing the management side, which is great if you're a manager, and we love that aspect. He does carry his Bachelor of Science in Personnel Management and Industrial Relations, another feather in the cap for those of us who are in HR. And Don carries his Juris Doctorate from the University of Miami. He does serve as the State Director of Government Affairs for HR Florida and has been a past president of the Central Florida Human Resource Association, as well as the Human Resource Association of Broward County. He does carry 2 certifications in the HR world. One is the SHRM, which is the Society for Human Resource Management, and the other is the HRCI Senior Professional in both cases. Don frequently presents and publishes articles on wage and hour and employment law topics, and he has been recognized by his peers in various publications such as Best Lawyers in America and Florida's Super Lawyers. So I do want to turn today's presentation over to Don.
Thank you very much, Sandy, and good afternoon, everyone. It's my pleasure to be presenting this afternoon, and as I began to say just a moment ago, one might think all is quiet on the Western Front. Nothing seems to be happening in employment law. There's not been a lot in the news about it. The media seems to be focused on other matters these days. But behind the scenes, there's actually been quite a bit going on in employment law during 2017, both on the federal level, the state level, at the local level, and in the agencies. So what I thought we'd do here this afternoon is to try to catch you up to date on some of the regulatory developments that have been occurring and some of the risks that you face as employers if you're not aware of these developments and are not complying with the new laws that are being passed. So first, let's start with the federal developments. First, some good news. For years, public employers, such as state and local governments, your police departments, your fire departments, they were able to avoid paying overtime by instead allowing their workers to take what's known as comp time, or compensatory time off in lieu of overtime. So rather than paying their workers time and a half for hours over 40 in a work week, they would instead give their workers credit for those overtime hours and allow them to take time off in a subsequent work week. Unfortunately, private employers like most of you and our firm and AlphaStaff, we've not been able to use comp time. Instead, we've been required to pay 1.5 times the employee's regular rate of pay for hours worked over 40 in a work week. Well, most recently, actually in May of this year, we've gotten some movement in Congress on something, one of the few things they seem to be moving on. The House of Representatives passed what's known as the Working Families Flexibility Act. And basically what that law would do is to amend the FLSA to allow private sector employers to use comp time in lieu of paying overtime to hourly workers. So next slide, please. So as I indicated, this would give you a second option for your employees. Rather than paying them 1.5 times their regular rate of pay, you could give them 1.5 hours of comp time for each hour worked. Under the bill, the employee would have to use the accrued comp time as paid time off in a subsequent week. It would be paid at the employee's regular rate of pay when the time is taken off. And it's paid at the highest rate, not the rate at which it was earned, maybe weeks earlier or even months earlier, but at the rate that the employee is making at the time they take the time off. Employees would be able to accrue up to 160 hours, and they would be entitled to cash out their comp time at the end of each year and at the end of their employment. In fact, that would be required under the law that's been passed by the House. This bill has moved to the Senate now. It's in committee. It's not even a bill that would have to go to any type of a compromise type committee. It's a mirror image virtually that's in the Senate. And I'd say if and when they get around to looking at the bill, it does stand a good chance of being passed by the Senate and would likely be signed by the President. So some potential good news here from Congress on the federal level. The other thing that's happening on the federal level, you can see here in the next slide, is there's been some movement toward a paid sick leave law. Now, interestingly, the HR Policy Association and SHRM and the Chamber of Commerce, all of these organizations, which are usually what we would think of as being business friendly, have been pushing this in Congress. And the proposed bills that they're pushing would require multi-state employers who have 50 or more employees to pay 40 hours of sick time or allow employees up to 40 hours of paid sick time each year. So you're wondering, well, why would they want us to force us to do that? Many of us have paid time off now. Why are they doing this? Well, the idea behind it is there have been a lot of state and local governments, as you'll see in a moment, who have been adopting paid sick leave laws. And the hope is that we can get a uniform bill passed through Congress on the federal level that would preempt any of the state and local legislation. And it would also cap the sick time at 40 hours. So in the next several slides, you'll see a variety of different state laws and local laws that have been passed with regard to paid sick leave. The first one you see here is the Arizona law that went into effect July 1st of this year. It got past a constitutional challenge in state court, and it does require businesses with just 15 or more employees to provide 40 hours of paid sick time per year. It accrues at 1 hour for every 30 hours worked. So it accrues over time, and it's an accrual that the employees would be entitled to upon termination of employment. So that was one of the first laws to go into effect in this area. You can see Minneapolis has adopted a similar ordinance for employees who have worked 80 hours, just 80 hours in a calendar year. They would be covered, and they would get an hour of sick time for every 30 hours worked. The next ordinance you see is the St. Paul ordinance. That ordinance went into effect for larger employers July 1 of this year, and it will actually go into effect for all employers January 1 of 2018. Again, a similar scheme. It requires that employees be permitted an hour of sick time, paid sick time for every 30 hours worked, and they can accrue up to 48 hours in a year. Like Arizona, Minneapolis, St. Paul, you can see in the next slide, Cook County, Illinois, which you all probably know as Chicago, also has adopted a paid sick leave ordinance. It requires very little work be performed, actually, for somebody to be covered, just 2 hours of work within the city, and then all of a sudden the employee is covered, and they end up being entitled to up to 40 hours of paid sick leave in every 12 months. You'll see in the next slide another movement in state law developments. So we first have this paid sick leave concept. The other thing that state and local governments are doing is taking a look at pay equity. There's been a lot of talk about this on the federal level, whether or not men and women are being paid equally, and whether or not we ought to get away from the traditional equal pay concept and move more toward a concept of comparable worth. And that's what we see in the legislation that's being passed. There is a typo here that I noticed last night when I was going through my slides. This law actually went into effect July 1, 2017. That is this year, not next year. And the law does require that employers pay men and women the same amount for doing different but comparable jobs. So this is different than the traditional equal pay concept in that the jobs don't have to be virtually identical. Instead, if they're comparable, equal pay would be required. The other thing that this pay equity law does is it prohibits secrecy policies. Similar to the ruling that was issued by the National Labor Relations Board last year under Section 7 of the National Labor Relations Act, employers would not be permitted to have a prohibition in effect stopping employees from talking about their pay. That's deemed to be a concerted activity that they have a right to engage in. And Massachusetts now has codified that as part of the state law, saying that you can't require employees to keep compensation secret. They ought to be able to talk about it with their fellow employees. So the policies that we've all been familiar with for years that are in many handbooks that I've seen that say employees cannot discuss compensation, those policies would be invalid under this law. The other thing that this Massachusetts bill did is to prohibit employers from asking about past salary or compensation during the interview process. The idea behind this is because women traditionally have made less than men, if we ask about salary during the interview process and we set their incoming salary accordingly, we're perpetuating the effects of past discrimination. So there is that prohibition in the law as well. And you can see there's significant penalties for a violation of the law. So Massachusetts has gone beyond some paid sick leave concepts that they had adopted previously, and now they've gone to a pay equity concept. Oregon has done the same thing, also prohibiting pre-employment inquiries. That goes into effect in October of 2017. And then also adopting a specific prohibition against sex-based pay discrimination. Finally, it has a comparable worth or comparable character requirement in the bill. In New York, Governor Cuomo has signed two new executive orders. One of them does deal with pay equity, and that is the latter, the Executive Order 163, that prohibits employers from, and specifically New York agencies, from asking applicants about their prior salary. And then he also signed Executive Order 162 that requires state contractors to disclose job titles and salary for employees working on a contract. The idea behind that is they can start to gather pay data similar to what the Equal Employment Opportunity Commission intends to do in coming years to enforce the Equal Pay Act, but in this case on a local level. In addition to these pay equity bills, the states and local governments are taking particular aim at the pay history issue. And you'll see in the next slide here, Delaware has enacted a pay history ban. We also have those in New York City, Massachusetts, Oregon, and Philadelphia. They haven't actually been signed into law yet, or have not gone into effect yet. But this is a trend we're seeing, and that's really what I wanted to communicate to you all today, is that there are trends developing. We're starting to see a move toward comp time being allowed. We're seeing a move toward paid sick leave laws. We're seeing a trend toward pay equity laws, laws that prohibit you from asking about pay history. All of these things are things you need to be aware of and be proactive with regard to, particularly if you're in those jurisdictions. But even if you're not in those jurisdictions, you need to be thinking about possible amendments to your policies and your practices so that you're prepared for these developments as they go into effect in your state or in your locality. Other state movements we've seen, there's been a lot of developments on ban the box. And basically what ban the box is, it's that box that you see on many employment applications where the employee or applicant has to check whether or not they've ever been convicted of a crime. And many states have decided that they don't want to permit employers to make such inquiries until after an offer has been made. So once you make a conditional offer, then you could do your background check and inquire into criminal history and deal with the criminal history as appropriate under the EEOC guidance. But before that point, they do not want you asking the question. So all of these different states you see listed here have banned the box for public employers. Florida actually had such a bill pending this year in the state legislature, and it almost got through for public employers, but not for private. And then you'll see in the next slide a number of different states who have adopted ban the box legislation that applies to private employers as well. So again, here's a trend we see developing. You need to get ahead of the curve and be prepared for this type of legislation in your jurisdiction. Whatever you can do in terms of modifying your applications so that you're prepared, you're well served by doing that. And I mentioned a moment ago the EEOC guidance on the consideration of arrest and convictions in connection with employment decisions. Basically, the EEOC has said you cannot make decisions based on an arrest record or a conviction record unless you can show that it's consistent with business necessity and job related. You can't make any decision based on an arrest, and with convictions only if they're job related and consistent with business necessity. So because that prohibition exists anyways, one would wonder why you would ask that question on your application. You might as well get rid of it and deal with it as part of your background check process, deal with it appropriately under the EEOC regulation. So one last trend we've seen on the local level, not surprisingly out of the Pacific Northwest, Seattle has adopted an ordinance for predictable scheduling. And basically what this is designed to do is give hourly workers, particularly in retail establishments or fast food establishments, or I guess perhaps in Seattle at the local Starbucks, these employers would have to give their employees some advanced scheduling notice so that they're not called in at the last minute and only paid for a couple of hours. Instead, if they are on call, they would earn wages even for time that they did not work unless they had certain advanced scheduling notice. So one last trend we're seeing on the local level, there's been a good bit of talk about this on the national level as well. So I think this is, maybe behind paid sick leave. This will be the next movement we start to see, along with an increase in minimum wage to $15, which many states are pushing as well. All right, so those are some trends in legislation, both on the federal and state and local level. Now let's take a look at some agency developments. The first set of developments coming out of the Department of Labor, to better understand what's happening there, you need to understand a little bit about the new appointee as Secretary of Labor, and that is Alexander Acosta. He was confirmed by the Senate in April, one of the earlier confirmations. He had been on the National Labor Relations Board previously, so he's very familiar with the DOL and also with the government and the way the government works at the DOL. He is perceived as being employer-friendly, though he has also been a member of the Civil Rights Division of the Justice Department. So he has enforced the laws protecting employees as well. So somewhat balanced approach. From what we know, it appears that he is going to try to return the DOL to an era where they used to try to work with employers to help them correct errors and correct mistakes rather than simply punish employers for violations of the law. So we hope to have, employers hope to have a better relationship with the DOL going forward. One of the things that's come out of the DOL, and particularly the wage hour division of the Department of Labor in the last couple years, are the overtime rules that were passed in 2016 by the wage hour division. And I'm sure most of you remember when this happened. Basically, what the wage hour division did was they said they wanted to re-examine the exemptions in the law, the Fair Labor Standards Act, from minimum wage and overtime. And those exemptions apply to executive employees, administrative employees, professional employees, outside salespeople, computer-related occupations, and they went about revisiting the regulations by asking for public comment. And we all believed that we were going to get these new regulations that defined who would qualify for the exemptions based on certain duties they performed, and we were all hoping for more clarification as to who might actually be an exempt administrative employee. Instead, what we got, quite simply, was an increase in the salary level required for somebody to be considered exempt. Nothing more, nothing less. And what they did is they said that for somebody to be exempt, instead of making $455 a week, they have to make $913 a week, taking the minimum salary up from $23,660 to $47,476. In response to this overtime rule, what many of you likely did, and I know a lot of our clients did, is examine who you treat as exempt and determine whether or not they still qualified as exempt under the new rule. Now, the new rule was scheduled to go into effect December 1, 2016. So many of you probably reclassified employees. Perhaps you even increased salaries of employees so that you could maintain their exempt status. Lo and behold, state of Nevada and a number of other states sued the DOL, contending that the wage hour division did not have the authority under the Fair Labor Standards Act to adopt this minimum salary level, that the DOL did not have authority to set the salary basis for the exemptions under the law. And they filed suit in Texas, which was probably a good move. Some of our more conservative justices are in that state. And they got a federal district judge, Judge Mazant, who went along with their argument and enjoined implementation of the rule. So a lot of us who had not made changes, a lot of employers who had not made changes, breathed a sigh of relief. Phew, we don't have to worry about this increased salary level. Our people are still exempt. And that's where it stood. In fact, that's where it stands right now. That ruling, that national injunction that stopped the implementation of the overtime rule is on appeal to the Fifth Circuit Court of Appeals. And the overtime rule did not go into effect. So what's going on at this point? Well, just recently, going back a slide, just recently, in the preceding slide, you will see the DOL has filed their reply brief with the Fifth Circuit Court of Appeals. They surprisingly are contesting the district court's ruling that they did not have authority to establish the salary basis. So they're basically saying, court, you're wrong. We did have the authority to set the salary basis. But while we're saying that, Judge, we want to let you know that we don't really like the salary basis that was adopted under the previous administration. And we're going back out for public comment right now to see what the salary basis really should be. But in the meantime, court, please go along with us and say that we still have the authority to issue a salary basis rule. So it's a little bit of an interesting argument. You know, on the one hand, they're trying to have the ruling overturned, but they don't want the salary that was adopted by the prior administration. So we're up on appeal now. Where does that leave you? And that takes us to the next slide. Basically, the DOL has gone out asking for public comment. While this case is up on appeal, oral arguments probably not for a couple more months, so we probably won't get a ruling from the Fifth Circuit Court of Appeals. In the meantime, the DOL is asking for employers to comment on a number of different questions, and these are some of the more pertinent. Whether or not the salary should have varied based upon different factors like census, the state, maybe regions of the country, whether or not there should be different salary thresholds for the different exemptions, whether employers who increase their salaries in anticipation of the rule and other strategies would be eligible, whether those employees would be eligible for overtime under the new rule, or are they going to be exempt under what was going to be the rule. They're also asking whether or not the exemption that relies solely on duties and not a salary at all would be preferable. And then finally, they're re-examining whether or not there should be an automatic increase in the salary basis over time, which was in this overtime rule that was adopted last year. So public comment is required, you'll see in the next slide, by next month, September 25th to be specific. I'd say it's unlikely that the circuit court will rule before then. However, it's also unlikely that the DOL wage hour division is going to have enough time to get out new regulations before a ruling of the circuit court. So, moral of the story, if you did not make changes prior to December 1st, you still need to be thinking along those lines. At a minimum, you need to be keeping track of hours worked for anybody who might become non-exempt under the overtime rule. And if, in fact, that overtime rule does go into effect retroactively, if the Fifth Circuit overturns the district court, then you need to be prepared to make back payments to people under the overtime rule that was adopted last year. As you can expect, there will be legal arguments over whether or not retroactive application of the rule is appropriate. You can bet that the employee attorneys, the plaintiff's attorneys, will argue for retroactive application. Moral of the story, be sure you have some record of hours worked for anybody who you think may become non-exempt. All right, so that's the overtime rule. Other agency developments, this one's interesting. President Obama had actually issued an executive order which stated that employers who had government contracts valued at more than $500,000 had to report to the government basically any violations of federal employment law. So if you were applying for a federal contract, you had to disclose, or if you had a federal contract for over $500,000, you had to disclose any type of violation of federal employment law. There's been a change in that regard, as you can see in the next slide. The Trump administration and the DOL pushed for a repeal bill, and in fact, that's exactly what got through both houses. You didn't hear about this in the media, but in fact, that executive order was repealed, and President Trump also signed his own executive order that revoked the prior executive order. So now federal contractors don't have to report violations as part of the bid process. So the fact that you may have an inadvertent violation along the way is not going to prohibit you from being eligible for federal contracts, which it would have under the prior executive order. Some other agency developments on the federal level. You can see there's been a development in terms of record keeping. Under the Volks rule, basically under a prior ruling from the DC Circuit Court of Appeals, they had said that OSHA could not issue citations for record keeping violations beyond a 6-month statute of limitations. That was changed, and what the Obama administration had done has said that they could look back 5 years, which was a different statute of limitations than OSHA, intended to be for ongoing type violations of the law. This Volks rule has been re-implemented, as you can see in the next slide. And what we now have is a return to the 6-month statute of limitations, so that OSHA can only issue citations for record-keeping violations for a period of 6 months. They still have the power to go back farther on ongoing violations, and particularly violations of safety regulations that they have issued, but not simply record-keeping violations. Another OSHA rule that private employers found disturbing was what was known as the walk-around rule. Under the Obama administration, OSHA had ruled that your employees, if you're in a non-union environment, had the right to have a union representative accompany an OSHA inspector during an inspection of your workplace. So it was a way that unions were using, frankly, to organize non-union employers. That is, they would learn where OSHA inspections were being done, and then they would try to accompany employees and the OSHA inspector on those inspections as an opportunity to get to know other employees within the workplace and do some organizing. So this has been reversed. The OSHA in April announced that it had changed its policy, and employees in non-union workplaces no longer have that right to be accompanied by a union representative. So that is certainly a favorable move for non-union employers who do not wish to be organized. So you can see we've had a number of different developments on the federal level with legislation, state and local laws, different types of paid sick leave, pay equity, and then agency developments. Other developments that we've been seeing at the forefront of employment law involve cases that deal with LGBTQ+ issues. You can see a couple of cases here. Most of them, including that North Carolina ordinance that most of you all heard a lot about in the news, most of these cases deal with the right to use certain bathrooms depending on gender identification or whether or not an individual is transgender. But the cases are starting to go further and apply Title VII's prohibition against sex discrimination to cases involving sexual orientation as well. So we are seeing, a lot of movement in the courts in this area, and it's likely that they will continue to try to expand protections, equal protection under the law for the LGBTQ community. Finally, the last thing I wanted to talk about this afternoon as a recent development is the ongoing trend for states to legalize marijuana. And you can see here there are a number of different states that have legalized medicinal marijuana, and then also states that have legalized recreational marijuana. Now, for you employers, that poses some issues. Most of you have drug-free workplaces, I would assume. The question becomes, well, if it's legal in my state, do my employees have a right to have it in their bloodstream? Can I test them? And if they test positive, am I able to keep them out of my workplace? The rulings thus far have been saying that employers continue to have the right to maintain a drug-free workplace, and positive test results can be used to take adverse employment action against employees. So far so good, but I think as we see more and more states adopt these types of laws, the next step will be protections afforded to employees from discrimination based upon their use of marijuana in those states that are permitting use of marijuana. Not to say they can be high in the workplace, but they may be able to use it outside of the workplace and not be disqualified simply because of a positive test. So these are the trends we're seeing. I hope that this has helped you to see those trends, understand the trends, and perhaps be better prepared for some of the risks that lie ahead for employers. I'm happy, we've got plenty of time. I'm happy to answer any questions that you all might have. There's a Q&A feature in the program at the bottom of your screen. Feel free to type questions in there, and I'll be happy to answer them.
Okay, I'm going to jump in here, Don.
Okay.
As people may be typing their questions, I want to thank everybody for being here today, and I trust that you have learned a thing or two about what's going on in the employment world as far as regulations go and other things that are critical to you maintaining hopefully a risk-free environment. If you do want copies of the presentation, you'll see a phone number as well as a email address there. Please feel free to reach out. I would say reach out through the email address. It's going to be quicker, but feel free to request those. Also, we do have another webinar coming up, September 14th, and it is one that most employers are finding that these things happen more and more as you know, I think we're a very litigious society, and I certainly, as an HR account manager with AlphaStaff, hear from many of you that employees complain that certain behaviors have happened to them that may or may not fall under harassment and or discrimination. So that webinar is brought to you next month, presented by Amber Tyson, one of our HR account managers, and it's to help you ensure a workplace free from harassment and discrimination, and also to understand what those actually mean. Oftentimes people have the trigger words, but it falls short of those situations, but still, we want to help you avoid those risks or things that can happen from those allegations. And as always, you can reach out to your own HR account manager or call our office, our 888 number. We also have a feature on our website that you can reach out as well. So I'm not seeing any questions on my end. Don, are you able to see those?
Nor am I. No, I don't see any questions. Certainly willing to answer questions in the future. If you have questions, reach out to your contacts at AlphaStaff, and they can certainly get through to us at Jackson Lewis. We'll be happy to try to help. It looks like one question is coming up now. Oh, the solar eclipse.
Yeah, I've actually had that question pop up, Don. So yeah, thanks, Grace.
Well, we have had a number of questions about employers and what they should be doing with regard to the upcoming eclipse on Monday. There are a variety of issues that might arise in connection with the eclipse. I think the primary question we're getting is, do we have to allow people time off to go view it? And the answer obviously is no. I mean, you have the right to tell your employees when they're expected to be at work. Should you restrict them from doing that? You know, if they want to go outside for a short period of time, it's not going to interrupt your workflow in any way. Most employers would probably allow that just from a morale standpoint. It's a positive thing to do. If employees want to travel to Kentucky for the day to see it where it can best be seen and take a day off, you should probably handle that like you would handle any other request for time off. If they have time off available to them, permit it as long as it doesn't interfere with your workflow. Finally, some employers we've heard are organizing viewing events where they are distributing glasses and allowing their employees to view the eclipse, go outside. It's kind of an opportunity for everybody to get together and enjoy each other's company. Nothing wrong with that. I think it's a very positive thing to be doing for the workforce, kind of camaraderie, team building type of thing. But understand there are some potential risks there if you have not informed them of the dangers and provided adequate protection. Then there could be some potential liability for a work-related injury under workers' compensation. The same is true if you have employees who work outdoors who may be looking at the sun during that time. You should be informing them of the dangers as well, and providing protective equipment or eyeglasses as necessary if for some reason they would be looking at the sky during the day in their work. So that's generally the questions we've been dealing with on that front. I hope that answers your question, Grace. Are there other questions?
Yes, Don, there was a question. Being the fact that there are several regulations that are kind of in a hold pattern, the question was, what do we use as a resource in the meantime? And I'd like to throw that out that you do have, if you are one of our clients, you do have an HR account manager that is always there for you should any of these things arise. So I would say that's your best bet. And from there, we liaison either with Dawn from Jackson Lewis, our internal legal team, or our other service areas. So hopefully that answered that. Mm-hmm.
Yeah, I think that's good advice. You know, because a lot of these things, as I indicated, that are on the forefront, it's better to be proactive and start looking at what the options are and developing appropriate policies and be prepared. And AlphaStaff can certainly help you do that.
Great. Any other
questions?
We're in stereo.
Okay.
I appreciate you being here today, Dawn. Thank you so much. Always learn when I talk with you. And everybody, I hope you have a great day. And remember to mark your calendar for September 14th and our next webinar. Thanks so much, everyone.
Thank you, everyone. Good afternoon. Bye-bye.
Bye-bye. Excuse me.